My name is Lindsay Schube. I am a partner at the law firm of Gamage and Burnham. I am here today to speak to you primarily about jurisdictions, cities, counties, how you deal with zoning decisions and building permits, and what you guys need to know as you come off on this journey.
And I'm Nicole Ricker. I'm Lindsay's partner at Gamage and Burnham. And my part of the presentation will focus on establishing yourself with real estate, whether it's by lease, purchase, joint venture, and what you need to look out for in terms of pitfalls. And I'll also provide you some pros and cons for all of those options.
Perfect. Okay, so I'm going to kick things off, and then Nicole will join us in just a minute. So an important and very confusing part of the marijuana regulatory process is the dual regulatory process. Who has the authority to regulate marijuana establishments? So that's the license that will be given out. Well, that's the Arizona Department of Health Services. You saw from Tom and Megan and everyone who works in the Department of Health Services, they regulate the licenses. But a very important piece of this puzzle that people sometimes forget about is the property. So who has the authority to regulate how you use your property? Well, you don't, even that's confusing. It can be the city, it can be the town, it can be the county. You have zoning issues and you have building permit issues. And a lot of times those issues get overlooked as you are going through this process. But we're here to talk to you a bit today about it because it's not something that people spend time thinking about. But your jurisdiction that you choose to locate in and the property that you choose is actually one of the most important parts of your dispensary, cultivation, manufacturing, or infusion. So again, dual regulatory process. It does get confusing. Sometimes cities try to overstep and get involved with decisions that are state questions, and then then you have all these city rules and regulations that you have to be aware of. So starting very, very, very globally here, it's important to remember the branches of government. So not only at the federal level, but at the state and at the city level. So again, at the federal level, we all know you've got the president, you've got the judicial branch, head by the Supreme Court, and then you have the legislative branch, which is Congress. These levels of government are very important also at the state and city level. So again, at the state, the executive branch is the governor, right? Then you've got the whole judicial branch. And there may be areas of law that I do not practice in, but if there are disputes between parties, they end up in the judicial branch, right? In the courts, and can potentially end up in the state Supreme Court. But then the legislature, so the legislative branch at the state level, comes up with statutes. Those statutes and rules that are adopted are very important, and they're very important for you to know. But that has to do, again, with the Arizona Department of Health Services and the regulation of the establishment license. The branch of government that a lot of times we forget about is the city, right? So we've got the city council. We have a judicial arm in the civil government, in the city government. We've had a client go to jail over a fence. It was a big, just long, complicated story that we don't need to talk about. But building permits, zoning, code compliance, they have a judicial branch in the city process, and it's very important. And then there's also, there's the legislative branch, city council and zoning ordinances, building codes, all those things. So again, we're going to focus our discussion today on the city part, but it's important that you distinguish between the two of them. So again, at the state level, from ADHS, there's Prop 203, which was the medical marijuana regulatory framework. And then there's Prop 207, which was the establishment marijuana regulatory framework. Not only is that different at the state level, but it's different at the city level. And I'm going to say something now that I'm going to repeat, and we're going to, continually review through this hour that we're together today. But the Prop 207 that the citizens voted on, allowing these establishment social equity licenses, gave local jurisdictions the ability to not allow establishments in their jurisdiction. So to not allow a dispensary that is establishment only in their city. Most cities today, and we're going to get more into this, but most cities today, their zoning code does not allow you to have an establishment only dispensary. Now, are we going to fix that problem? Absolutely. Don't freak out, turn it off. We will figure out how to get that done, but the zoning is really important. And as you look through the local zoning ordinances in the local cities or counties, make sure you distinguish between what the medical rules are and establishment. Okay, so hopefully, again, we're going to touch on that. I'm going to sound like a bit of a broken record, maybe like I'm talking to my children, and repeat myself, because I know that's what moms do sometimes, is repeat themselves. But it's just really, really important to know that the zoning right now in most cities, towns, and counties in Arizona do not allow for establishment only. Zoning generally, because we're going to touch on that after Nicole, I'm going to come back, but the zoning, the states have the rights to zone, but they authorize the cities to zone. So every city has their own zoning rules and their own building codes. What does that mean? Job security for people in zoning. Look at that map. Buckeye, Goodyear. Levine isn't actually a city, so I don't know why Levine is on there as a city. Ahwatukee and Levine are subsets of Phoenix. They want to be their own city. Chandler, Gilbert, Mesa, Queen Creek, Cave Creek, they all regulate zoning and building permits differently. Then what you don't see on that map are county islands. So you do have pockets of property, and I'm using the greater Phoenix area, as an example, but it's the same thing whether you're in Pima County to the south or Yavapai County to the north. So every city, if it's incorporated, has their own zoning rules, building permits, and city or town council, but then you also have pockets of land that are county islands. Guess what? They have their own zoning rules too. So the due diligence that you do on your property is very important. And it doesn't stop with just how you purchase or lease your property that Nicole's going to get into, which is very, very important. But the due diligence that you do on your property is very specific to your property, and make sure you do your homework. If I had $1 for every time someone came to me and said, "Oh, but my realtor told me it was allowed," or the broker said it was zoned properly and I didn't need building permits. No, check and double check, right? You have to make sure that you are advocating and checking and double checking everything that you do. And I'm telling you, all these individual cities have their own rules, their own mode of operandi. We'll get into kind of some of the nuances of how you get into that. But again, do your homework. Make sure that you are doing your own due diligence on all of your properties. I'm now going to step aside, hand the mic over to Nicole Ricker, who will talk to you about real estate.
All right. Hi, I am Nicole Ricker, and I am one of Lindsay's partners. Lindsay and I work together all the time, especially on cannabis matters. And I think she did a really good job of explaining to you how the government and the government regulation affects your ability to secure real estate and operate a cannabis business in the state of Arizona and your particular jurisdiction. What I do is the private party contracts and private party relationships. So this is she's got the 2 tiers in hers, but globally there's the zoning and land use and then the private party contracts, and that's where I come in. I do just want to hit on something Lindsay said at the end. She talked about due diligence. That is something you'll hear often in our practice. It just means doing your homework. So you've got to do your homework. You have to do your homework with someone like Lindsay, and then you have to do your homework in terms of how you structure your interest in real property. So we're going to talk about establishing an interest in real property. There are a few ways to do it, but there's good news for the social equity license holders. For other licenses, the license attaches to real property and it stays with the real property unless moved. The social equity license is personal and relates to the person, but you still need real estate. And there are a few ways to get an interest in real estate. There are two basic ways to establish yourself at a property. One is via lease, and the other is by purchasing the property. They both have a few pitfalls, and they both have some real good pros that go with them. I will talk about leasing first. I think that it's the more common way of getting interest in real property and opening up your shop. It's also the less expensive way and the less time-consuming way. And given that real estate is going to be your biggest expense, it's enticing to get to lease a property. So what's a lease? A lease is an agreement between a landowner and a tenant, and it governs the relationship between the landowner and the tenant and all of the tenant's rights to possess the property, do their business at the property, and stay at the property. I think it's probably a good idea to talk about some pros and cons with leasing. The pros with leasing, as I said at the top, are that it costs less than buying a piece of property, which is a big one. It's also less time consuming. I don't want that to be construed to mean that it's not time consuming and not expensive, because it's both. But it's less than purchasing a property. So again, due diligence. You're going to want to look around for a space. A lot of your client base, your employment pool, and your branding will relate back to the space that you choose. So if you're leasing a space, you don't have to stay there forever, but you're going to open your doors there. So you want to look around at what the neighboring uses are, where people live. Is it close proximity? Does it have highway access? And all of the other due diligence / homework you'd want to do generally. And that is really step one. That does take some time. The next thing that takes time with leasing is convincing a landlord to rent space to you. There's good news on this front too, because cannabis and because marijuana business has been in Arizona for a number of years, the wheel has been greased. The first people who went to landlords to lease them property to open a marijuana business did not have much luck, and it was a lot of educating landlords and landowners and lenders about the risks. But at this point, people are open to leasing space to marijuana businesses. But part of your due diligence is going to be talking to the landlords and educating them. In your pocket, you have the fact that marijuana is very regulated, and the Department of Health Services does a really good job regulating the industry, and so landlords may have less hesitation to lease you space because they know that DHS is watching and that you have laws you have to abide by. So not as time consuming as purchasing, but still time consuming. And then another piece of leasing property is entering into a lease. We'll talk about the actual lease a little bit later, but that is also somewhat time consuming. Again, less time consuming than purchasing a property. Another pro of leasing is that you have more flexibility. You can move. You generally lease for a shorter amount of time. If you buy the building, you generally can't move unless you have a real good plan B, because you've got a lot of money sunk into the real estate and you're not as mobile. What are the cons to leasing? I think number one, you have a landlord. And I think most of us have had landlords before. They're not the best. They tend to get involved in your business when you least want them to be. And operating in the commercial space is no different. Landlords will be very generally heavily involved in the startup to your business and the lead up to opening for business. And then they will generally also be somewhat involved in making sure that what you're doing is not affecting the value of their property. Another con, you will just have less flexibility with how you use the space. You will generally not be able to improve the space without your landlord's consent, which can cost money and time. And if you do improve the space, you're going to leave your improvements at someone else's property unless you negotiate which ones you can take with you. So that's something to be mindful of. Other cons of leasing. If you default under your lease, so if you breach your contract, you can lose your space. We have had a number of clients lose their space, and it can be a big ding, especially to a new business. So that is one of the cons. And I think the final big con is that landlords will generally require that you indemnify them for anything that happens as a result of having marijuana on the property. Indemnification is, it's a long way of saying if the landlord gets sued because you have marijuana on the property, you, tenant, are going to make landlord whole. You're going to have to run the cost of their defense. You're going to have to pay them for their losses. The list goes on and on. And that is something that's a little bit nuanced, but I mention it only because it's something to be mindful of. Indemnification, protecting the landlord, very often just gets put in a lease and no one ever looks at it until there's a problem, and then you realize what you've done, and it's a major undertaking. So, with leasing, you have flexibility, less money up front, and less time up front. But on the back end, you will have to deal with the landlord. They will be very involved in your business, most likely. You don't have quite as much flexibility with how you use the space. You have to follow your contract to the letter of the contract so that you don't default and lose the space. And you are going to have to protect your landlord. That is the deal. The landlord says, hey, I'm willing to lease you this space even though what you're doing violates federal law, but in exchange, you're going to protect me from all of my losses related to that. So I think that's leasing in a nutshell, pros and cons. We'll come back to leasing in just a second. The second most common way to find real property is by purchasing it. So what are the pros of purchasing property? Number one, control. You have no landlord. You will be in control of what happens at the property. When you try to process for your permitting and your entitlements with someone like Lindsay, you will have full control over what happens, and you won't be constantly managing the relationship with the landlord because they will have to be involved in that. You will also have control over how you use the property. If you take on too much, you can sublease space to a compatible business. You can make the building bigger if you're doing great and you want more space. Another pro is that you will have residual value in the building. So you're not just paying rent to someone who takes the rent and then gets their profits. You're actually investing in real property you own. And so at the end of the day, you'll have most likely a good asset, maybe a good piece of collateral that you can borrow money on. It'll give you some good business planning. And then another pro is that you may actually be able to turn a profit, right? So if you did get more space than you need, you'd be able to rent space, and that can sometimes offset some of your cost of establishing the business and buying inventory, buying equipment and machinery, etc. So it's got a lot of pros. Here are the cons. Costs a lot of money, and it takes a lot of time. So those are really big hurdles to getting into the purchase side of things. Talking about money, there are opportunities for joint venture. There are a lot of players in this space, some of our clients especially, who are in the business of funding marijuana businesses and marijuana companies and helping companies grow. There, like anything else in the world, there are really good players in this space, and there are some that don't necessarily bring as much to your business. So my catchphrase, Lindsay has her catchphrase, mine is due diligence, right? Find out about the people, do your homework before you let someone in the door, even if they're buying you real property. So just to recap that, on the purchase side of things, the pros are you have control, you'll be building capital, you have an asset at the end of the day, and it gives you flexibility in terms of using the building and the interest in real property as collateral to fund your enterprise. The cons are time, money, and having to navigate getting equity and joint venture partners to actually be able to purchase the building. That is a whole nother kind of can of worms that we'll revisit. Oh, I have sublease up there too. You can sublease. I think that's less likely in the short term given the establishment rules and zoning and the newness of it all. But maybe in the future, subleasing is an option. Subleasing is a little bit less expensive and less time consuming than leasing, but I don't think it'll be available quite yet for all of you. Okay, so let's go on to more particulars about each of these and what the documents we would be doing look like and what you should be aware of. So we're going to start with purchasing. Purchasing is a very traditional practice. There are pretty traditional purchase and sale agreements. People have been buying and selling property forever. But there are particular concerns with marijuana business. Luckily, we've been doing this for a number of years and we've seen most of these. And so there is a good set of protocols for purchasing property to be used for marijuana businesses. So my favorite term again, due diligence. When you're purchasing real estate, you want to do your due diligence. And in this case, for purchase, you want to do land use and zoning diligence, which Lindsay talked about and we'll talk about again. You also want to do due diligence on private covenants. And what are private covenants? So private covenants are agreements entered into by parties that have an interest in real estate that affect your ability to use the property in the future. They're also called encumbrances. Basically, if you own a property, you have the ability to record something in the official records of Maricopa County that affects how that property can be used, sometimes and forever. Part of the due diligence of purchasing property is getting a title report. And the title report is prepared by a title insurer, by a company that helps you buy property, by managing the escrow and managing the title. And they will put the property into their database and they come out with a giant list of things that affect the property. And what a lawyer can help you do is look at the list of things that affect the property and evaluate if any of those preclude you from having a marijuana business on the property. Because this is a very heady conversation if you're not in real estate, and I know you're not going into the real estate business, I'm gonna give you some examples so that this starts to make sense. So you wanna purchase a property. You call me, we make a contract, you call another lawyer, they make a contract, and you get a title report. Let me back up for a second. I actually recommend you get a title report before you go through the pain of a contract. You'll find out why in just a second. So back it up. Before you draft the contract, get a title report. We'll pull up the title report. Someone will read all of the documents. Very often, there will be plats, which are maps of the property that have notes on them that say what can be done on the property. There may also be CC&Rs. There may be restrictive covenants in deeds. Those are all terms of art for just a document that affects your property. And what we'll do is we'll read all of those, and sometimes in the fine print, a plat, which is a map or a document, will say something like, this property must be used as allowed by state and federal law. Seems harmless enough, except that it clearly doesn't work here, right? Because federal law still prohibits the possession and sale of marijuana. And if we see something like that sitting on the title to your property, it is a major red flag. And the most conservative analysis is do not proceed, right? Find another property. That is, unfortunately, the reality of having a conflict between federal law and state law. Sometimes these seemingly innocuous and good things that people did to their property are backfiring now because we have a federal and state law conflict. So that's one thing that we see very often. Another thing we see are CC&Rs. And very often, CC&Rs will say not only do you have to operate in compliance with state and federal law, but you may not be a nuisance. No odors, no noises, no lining up outside the building. Some of them even say things like your windows can't have covering. And you'll find this out maybe from someone else or later, but there are strict rules about what your building can look like and how you operate that may or may not comply with these private covenants on your property. And so again, we'll read all the documents. There can be hundreds of pages of them, and we'll let you know, hey, for the following reasons, this property is not suitable for what you want to do. And those are hidden, they're hidden pitfalls, right? Sometimes you'll be able to identify a property and be very excited about the location, about the zoning, about the existing improvements, and then we look at title and have to pull the plug. It's for that reason that I put this at the top of your due diligence / homework list. Check title. Check to make sure that you are allowed to have marijuana at the property, not from a federal level, state, local jurisdiction, zoning, but from a contract perspective. It's a very important thing to do. The last thing you want to do is raise funds, buy property, and then have to tell your investors, oh, hey, by the way, we actually can't use the property. Nobody wants to do that, and I don't want to have to tell you that. So do this first, check title. All right, another important part of purchasing a property that deviates from a regular purchase of property is that it's a little bit trickier to get title insurance when you purchase property with the intention of having marijuana at the property. Again, we've been doing this long enough that we have found certain title companies that will give you insurance. So it's really just a matter of, again, doing your homework, talking to the right people, making sure that the title company you choose to close your transaction and issue the title policy and ensure your interest in the property, because you're spending a lot of money, you want to get some insurance. Make sure that they'll do cannabis, marijuana deals. Not all of them will. Good news is there are options now. Okay, and then this isn't on my list, but the third thing that's really important is the contract itself. So when you purchase real property, you'll sign a purchase and sale agreement before you actually close and take title to the property. Not too many tricks here for marijuana, but there are a few. Generally, when you sign a purchase and sale agreement, you have a due diligence period. Again, I think I'm going to say that 100 times today. There's one more, due diligence period. This is one where, as the buyer, you have a certain number of days to make sure the property works for you. This is your title review period, making sure title insurance looks good. You'll survey the property, make sure you don't have utility lines running under your building. That's happened before too. Lindsay and I are just laughing. Make sure that you don't have septic tanks under the building. That's another good one. We've seen this all happen. So you enter into a purchase and sale agreement with a seller. You have some due diligence time. You're going to do all of these things. I think that where marijuana purchase and sale differs is that you really want to build in some contingencies. So you're going to want to put a property under contract so that you have the right to buy it. But at the time you put it under contract, you may not know whether you have the entitlement approvals that you need. And so what we typically look for in these purchase and sale agreements is some kind of entitlements contingency, a period of time for Lindsay to do what she does, talk to the city, check out building permits, check out possibilities. How big of a building can you build? Do you have adequate utilities, right? Because if you're running lights all day, you may need some serious utilities. That's something we do at the same time. And so again, rather than a typical short due diligence period where you're just looking at title, making sure you have an insurable investment, you really need to understand that you can do what you want to do. And so that's one of the documenting tricks. We want to make sure, if at all possible, that you can have some time to check out your entitlements. Now, for better or worse, it's a seller's market right now, and it may be very difficult to get that entitlements period, regardless of the fact that you may have people in your ear telling you, oh no, it's a real estate market, seller's market, no one's going to give you time. That is probably a risk I wouldn't take in your shoes, but you can evaluate that on a case-by-case basis. You really need enough time to understand that if you're spending that much money purchasing property or going under contract and going to lose escrow money, earnest money if you can't perform, that you have an out. And if you have to pay for it, you have to pay for it. But you really want to be able to get that out. I think that's the big one in terms of documenting a purchase and sale agreement. You know, in an ideal world, you'd also be able to get a financing contingency that says, oh, we have another 60 days after due diligence to find funds. I don't think that's possible in this market, but if the market changes, maybe that's something you can ask for. But again, you know, you have to evaluate each of these properties on a case-by-case basis, do your homework, make sure you know everything about the property before you have committed earnest money or are committed to close, so that you don't have a surprise. Now, we did talk a little bit about getting equity for purchasing. The idea of purchasing a piece of real property can seem daunting, especially when you see the current asking prices. It's a bit of sticker shock, but it is possible to raise equity for the purchase. Again, like everything else in life, raising equity takes time, and so you might want to get your equity in place before you go under contract to purchase or while you're under contract to purchase. But keep in mind, the better your due diligence, the more homework you've done, the more likely you are to get quality investors and quality contributors to equity. You know, if this is your first foray into business, you know, it's a really good idea to put a good team together so that you have a lot of help to do your due diligence, make sure you've got the right people on your team, make sure if you're getting equity from someone that it's a fair deal, and just get off on the right foot there. Okay, so that is the documentation we do for purchasing. I don't think I have a slide for the leasing documentation, so we'll just talk about it. For leasing, like I said at the start, it's a little less time, a little less money to the end where you can actually open up your business. Leasing documentation for marijuana businesses varies more than purchase and sale agreement documentation varies between marijuana and non-marijuana. You have a lot of the same concerns. The lease is generally, I would say, a 10 to 100 page document that governs your relationship with your landlord. And you still have to do title. You still have to do due diligence. It still applies even if you're a tenant, right? It doesn't only apply if you're purchasing. So still, step number one, pull title. Get a title company to pull title so that you can see what the property may be used for. Just a little story to make this more relatable. We have had circumstances where someone has leased a property, the landlord said it's fine. I own the property, you can have marijuana here, and then you look at title a little bit later because a neighbor's complaining, and you find out we can't in fact have cannabis here. Big expense, and an expense that was totally avoidable by doing your homework. So again, leasing, number one, pull title. Understand what restrictions apply to this property. Number two, get the lease draft from the landlord. And again, this could be 10 pages, totally manageable. It could be 100. It could be more than 100 pages. We've seen that. This is the time suck in leasing. I think that's the only way to call it, right? You've got to read this document. You want to get help reading this document, and you want to make sure that the document allows you to operate your business. You have to be very, very careful here. You will most likely see in any landlord's form contract, you may not violate federal law, you may not violate CC&Rs, even if we don't give them to you. All sorts of pitfalls. Because unlike when you purchase the land and it's yours and no one can kick you off, if you violate your lease, your landlord can kick you out. And that becomes very complicated, especially if you have marijuana in your possession. How are you going to move it? They can't have it, right? You can't just give your landlord the marijuana. So the lease has to be very, very particular to marijuana and provide for all of those contingencies. I could go on and on for days, but I think I'm gonna let Lindsay come back up here and talk to you about zoning and entitlements. I hope I did not put you to sleep. I hope we have an opportunity to talk about this again, and I'm gonna let Lindsay talk a little bit more about zoning.
Thank you, Nicole. And she had one more slide left, and I think this is an important one. Social equities are given to people, not property, or not places. And so in some of the previous, when we did the medical licensing, those applications had to be tied to a property. Now we get to do this after, which is great and gives you additional time. But again, make sure you don't get rushed in that process. So zoning, there's so much. Much like Nicole could go on and on for hours, zoning and building permits is what I spend all my day doing, right? It's mildly nauseating sometimes. But that's what we do, and there are enough nuances in here. So we're gonna hit it pretty quickly. But one thing I'm gonna tell you, and Nicole touched on it. So again, what Nicole talks about is private to private contracts, and what I'm gonna talk to you about is your private to public relationship, right? And so in private to private contracts, you have two parties who wanna work together to make a deal. Cities, might not. They don't have the same drive. When you have a private to private contract, it's a different animal than dealing with the city. The city doesn't care that you're sitting on a loan and you're paying interest. They don't care that you promised that you would be growing marijuana within a certain time frame. They don't have the same sense of urgency as a private to private contract does. But I will tell you, you're gonna get pressure from your landlord, you're gonna get pressure from potentially your broker, you're gonna get pressure from your real estate agent, and they are going to try to push you along faster than you wanna move. If I had $1 for every time someone said, oh, but my broker said it was okay. Well, your broker said it was okay. Great, your broker's saying you got zoning at the City of Phoenix. Awesome, close on that property. The cities do not have the same urgency in moving you forward. So zoning ordinances generally, again, most cities are broken up into districts: commercial, residential, industrial. All those districts have permitted uses. They also have development standards. Your building can be 35 feet high. You can be 20 feet from the rear property line, 10 feet at your side yard, and 20 feet at your front yard. Every piece of property in any city or county has zoning, it has permitted uses, and it has development standards. Also, when you're in these private to private relationships, don't think that the person before you didn't develop and violate the law. Don't assume that they got a building permit. But guess what? As soon as you own that property, your problem, not theirs. Again, sorry city, and sorry, I'm Canadian, sometimes it comes out. Sorry city, my building's over top of my septic tank, but I didn't do that. The other guy did. They don't care. Fix it. I don't care that it's gonna be $100,000 to fix that. It's now your problem. And it was a really, check to make sure the building isn't over a septic tank. That's just one of our most expensive fixes we've ever had to do. So that's zoning ordinances generally. So actually any piece of property, even if you're buying a house, I recommend you go to the city, make sure the people got the building permits. But then when you speak about marijuana, whether you have a commercial or industrial use, so you want to put the dispensary, you want to put cultivation, infusion, in every jurisdiction, you have to be a certain distance from certain protected uses. What's a protected use? A church, a school, a daycare, a park, residential property. You ask, what's the distance? Depends on the jurisdiction. So special. Again, job security. Every jurisdiction is different. Every jurisdiction has different protected uses. Every jurisdiction has a different distance that you must be from these protected uses. Now, some jurisdictions allow you to deviate those standards. You go to the city, you ask for a variance. Some jurisdictions allow that. Other jurisdictions, cities, don't. You will always, and actually, let me back up. You always have a right to ask for a variance from a protected use. Again, if any broker tells you, oh yeah, you can get a variance for that, don't believe them. Call the city, call me, call someone. And then also, and this is a really tough thing to say, but I'm gonna say it, everyone at the city doesn't always know the answer. Ooh. And guess what? If the city gives you the wrong answer, they're not liable because they're the city. If the guy who picks up the phone, who's the planner of the day, gives you an answer and it's not correct, if it doesn't seem right, check, double check. Due diligence, homework. If the guy who answers the phone, or gal, has only been there for a couple weeks and they don't give you the right answer, it's on you, it's not on them, which makes it tricky. And you know, the zoning ordinance will also tell you if a use permit is required or if, you know, your dispensary, cultivation, or infusion is permitted by right in that zoning category. And again, my theme is going to be very few cities or counties allow establishment only at the present time. So if you look in the City of Phoenix zoning ordinance today and you say marijuana dispensary, it will say medical is permitted, establishment is permitted as an accessory use. That means anyone who is selling under an establishment license, so just selling to the general public who is over 21 years old, following all the development or all the ADHS standards, can only do it in the City of Phoenix if you are a dual licensee. So we are going to have to fix that problem, but that's a problem that's going to have to get fixed. I don't know if it's going to be before these licenses are going to be given out or after. And again, I'm talking to people about it in all the jurisdictions right now. They're aware of it. I don't know how we're going to fix it though, but we can. Again, the approval process is three-tiered. There's an administrative approval process for marijuana. So that means you find a piece of property, let's say cultivation, Mesa, for example, has this process. You have a piece of property, you produce a survey that says you are X number of feet from all the protected uses, you meet all the standards that are set forth in the Mesa zoning code, you submit an application to the Mesa city staff, and administratively, that city staff person who's authorized to do so can give you approval to operate your marijuana business there. Again, Mesa doesn't allow establishment only. That's the thing that you're going to be sick of hearing from me. There's also a quasi-judicial process. For example, the city of Phoenix. If you want a marijuana use, again, it's only medical today, but I would assume they will follow the same process when they do allow for establishment only. You have to go in front of a hearing officer. You put an application together and you request a use permit. City of Phoenix, for example, is a jurisdiction that does allow you to ask for a variance from a protected use. So you can ask for a use permit for dispensary or cultivation and infusion. You can say, gosh, hearing officer, there's a school, but there's a canal there, so they may have a variance from that. But the quasi-judicial process has a test. The use permit test is a 2-part test, and the variance process is a 4-part test. And you have to go in front of a hearing officer. Now, anyone can show up and do these hearings themselves, so you can. But please, 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 if you do this, look at the ordinance, look at the rules, and as simple at the City of Phoenix, it's on the application form. Look at the 4-part test and address the 4-part test, because if you don't, you won't get approved. Quasi-judicial, again, using the City of Phoenix as an example, you go in front of a hearing officer, you get approved, denied, or continued. You have the ability to appeal to the Board of Adjustments, and then the ability again there to appeal to Superior Court. A legislative process, which some jurisdictions still have. Unbelievable. You have to apply for approval, and it goes in front of the City Council. So the administrative process is the best way to go. I'll give you a tip. Maricopa County, Mesa, Chandler, who else is administrative? Those are 3 that I can think of off the top of my head. As soon as you get into a public hearing forum, it gets more complicated because anyone can show up and give their opinions. Quasi-judicial should be a more predictable forum because it's a test. It is a 2-part test or a 4-part test. If you meet the criteria of the test, you should get approved, and there should be consistency. A legislative approval process does not have to have consistency. If a city council or a town council or if a board of supervisors in a county has to make that decision on whether you are permitted to operate, they can make it for whatever reason they want. Yeah, I just said that because the sky's purple in their world, and they just don't like marijuana. I've heard my favorite quote at a public hearing, and this was a planning commissioner, said, "I just don't like it. Anyone who does marijuana or drinks alcohol is stupid." There you go. Okay, no, you're not voting for me. But again, when you're part of a legislative process and people are allowed to have their opinion, I mean, we're all allowed to have our opinion, but it's allowed to sway into your decision-making process. It's tough. It's a tougher forum. You can get people to speak for you, against you, and it's confusing and can confuse the issue at hand, which it's supposed to be there. So, in a standard marijuana zoning ordinance, most of the time you're permitted to operate in industrial districts, industrial zoning. In many jurisdictions, you can put the dispensary only, so the retail component, in commercial. So I didn't put that in there. You see industrial districts, but grows, manufacturing, those all have to be in industrial districts. But that's not the only thing you have to worry about. Please, please, please look at setbacks, look at variances, how far or close are you from protected uses, and please don't trust. I don't want to say don't trust people. I sound like a jerk. Do your own homework, right? Like you would in anything. Do your homework. You may or may not need a use permit. You may or may not need a rezone. There's a number of different things. And the one thing I didn't touch on, but I've got a meeting tomorrow morning at 8 o'clock in the morning, is building permits. Building permits are very important. So let's say now you found a piece of property, you've figured out that the zoning works. Okay, we either have the use permit or we got a variance, and or you're far enough away from protected uses. And then you've got the private to private party contracts all in place, everything is good. Don't forget you need a building permit. And building permits, again, you need a good general contractor, you need good subs, someone who's familiar with the space. And when I say space, I don't mean your specific space, I mean the marijuana space. It always helps when you have and hire consultants who are familiar with and have done work in marijuana. Now, is that a prereq? No. If you have a good general contractor who you know, fine. But I will tell you, again, there are nuances, right, when you're in the marijuana space. But building permits are very important. And again, the head of building at the City of Phoenix says, communication, communication, communication. You need, and they don't have a dog in your fight. They always win. Be polite, be kind, try to work together to how to get you guys across the finish line. So yeah, I think, and again, in marijuana, is it with different things, you have yearly status updates, you have different compliance requirements, and we could go on for days and days. But Nicole, if you want to come up, real estate and zoning are a full-time job for Nicole and I, in not only in the marijuana space, we accept and really enjoy our clients in the marijuana space.